Well, 2013 marked the beginning of major law changes impacting estate planning, emphasizing techniques to cause property inclusion in a descendant's estate at death to get a basis increase. Well, Roger McEowen with the Washburn University School of Law joins us now for a further look into this. Thank you so much for joining us, Roger. Let's start with some background information on the basis step-up issue. Give us a little background on that.
Yeah, well, as you noted in the open, the rules really changed, effective for deaths beginning in 2013. And now that exclusion is so high for the vast majority of people, there's no worry about having the federal estate tax apply at death. That credit now will offset that first $11.4 million in taxable estate value or even taxable gifts during life. And so tax is not an issue for most people at death or for most farm and ranch operations unless you're really large. But property basis increase at death is important. And the rule that you get an increase in the basis of your property equal to the fair market value of that property at the time of death was retained, even though the exemption went way up.
So what are the planning steps to achieve a basis increase?
Well, basically what we want to do is the reverse of what we wanted to do prior to 2013. For a lot of people, when the exemption was so much lower, we employed a lot of planning techniques to try to shift value to others in the family or a business interest to others during life so that we didn't have as much taxable value in the estate. Now, with the exemption so high, for the vast majority of people, we want to cause inclusion in the estate, cause that the retention of power over that property so that we get the basis increase. So those are that's the basic overall plan now for most people. Don't make gifts, cause the property to be included at death, get a basis step up in the hands of your heirs as you pass it to the next generation.
So definitely some changes there. What about community property?
Well, people that live in the community property states, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, and a couple of states by election, Tennessee and South Dakota, you really have an advantage because basically what you're going to do in a nutshell is you're going to get a full basis step up in 100% of the marital property, where if you were in what we call the common law property states, you would get a basis increase in the deceased spouse's property, but only a half basis step up in the hands of the surviving spouse. So that's an advantage of those few states that have that unique community property system.
Definitely. Well, thank you so much, Roger McEowen with Washburn University School of Law, for helping us kind of navigate those waters there.